As I say in Tagalog, maganda umanga. That's good morning in Tagalog. We're doing healthcare immigration law. We're gonna talk about the nursing profession and the physician profession. This part of the immigration law is very different from let's say software engineers. You require a license, and it requires extensive amount of certification preparation work in order to even apply for an H-1B visa. We're going to start with Mr. Ayer with Carl Schusterman's firm in California. He's going to explain physician immigration to the United States and introduction to RN or nursing immigration. Mr. Ayer, please, you have the floor, sir. Welcome from California.
Thank you, everyone, and happy Friday to all of you there. It's still Thursday out here, and I really want to thank you guys for this opportunity to appear over the web. I guess Star Wars 7 is going to come at the end of this year. Maybe in another 20 years, we'll all have our holograms in Manila. That will be fun. I'm going to start with just to give an overview what we are seeing as practitioners of the healthcare workers from Manila. Of late, we see there has been an increase in the clinical lab scientist position. We are seeing a lot of Filipinos, and majority of them are actually studying in the United States, and they are getting their master's degree or bachelor's or master's. And increasingly, we are seeing the employers are, hiring these people. And we always have these challenges of H-1B visa. But other than that, that seems to be the big thing. And thanks to the movement of priority days in EB3 category, even the hospitals have slowly again started calling if they can start getting the nurses to the United States. That had stopped for a period of time, but now slowly it's picking up. Maybe Mr. Gorski can enlighten us the moment of this priority dates as to what's going to happen. Having said that, I'll just move directly to the physicians. Physicians, typically, it's a specialty occupation. Immigration never hassles us whether doctor is a specialty occupation or not, so that's pretty good. Most of the time, their work visa would be H-1B, but before they get into that stage, almost all of the physicians, with very few exceptions, come on a J-1 visa. They come on a J-1 visa to do their residency, and in order to get into the residency, they are required to pass the USMLE exams Part 1 and 2. And one of the great resources for USMLE Parts 1 and 2 would be ECFMG's website. They got all the necessary information, how to go about it for registration, for application purposes, what documents are required to be produced to take these examinations. It's a fantastic resource, ecfmg.com. One thing is, like any physician, any foreign physician who is going to be coming to the United States to perform to do their residency, the law requires that they are required to go back to their home country for a period of 2 years. And there is only way you guys, any of the physicians can get over that hump is by seeking a J-1 waiver program. Now, J-1 waiver, we will come to that. J-1 waiver is, before coming to the J-1 waiver, and before they start working in the United States, during the period in residency, they also have to clear the USMLE Part 3 exams. Once that is over, once they are licensed to practice any state they want to, they have to then agree to work in a medically underserved area. When there are many ways of getting the waivers. Most common that what we see in practice is going through this interested government agency. If the physician agrees to work in a medically underserved area for a period of 3 years, then they do get the waiver from going back to the home residency. Now, the process for getting the necessary waiver would be to, initially make an application to the CIS saying that you get that necessary number from the state, and then get in touch with the local state organization which is in charge of processing the waiver application, or through other government agencies. Make sure that we get the necessary documentation from the employer to show that they are actually serving the medically underserved area. Fill in the application, go to the state. Once they approve or agree that yes, this area is a medically underserved area and the physician can work there, they will approve, they will recommend the waiver and give it to they will send it to the Department of State. Once the Department of State also approves it, it goes to the CIS. And once CIS approves the I-612, then the practitioners can file an H-1B on behalf of the physician. And most important thing is the physicians who have received this J1 waiver are exempt from the cap number. This H-1B cap is really important. That's one thing which is keeping me tied to this chair, and I couldn't make it to Manila is because of the H-1B. We all know the H-1B cap starts on 1st of April. But the physicians are exempt. Once they get the necessary waiver, they are exempt from the waiver. Now, other than in other cases, in case if for any reason the physician cannot go and serve in a medically underserved area, there are options like if physician can prove that there is a persecution in his home country so that he cannot go back to his home country, or if they show that, in case if they return to their home country, it will cause exceptional hardship to their spouse or child. And then you can again submit an application to the USCIS with all the necessary documents showing the exceptional hardship to the USC or LPR spouse or child. And that would, and in case you can get a hardship waiver, again, you do not have to serve in a medically underserved area and you do not have to go back to the home country. I've covered this application process for the waiver application, but just to summarize, like you start with getting the necessary. Okay, this is not.
Raj, we're approaching 7.5 minutes. Please, you can go into RN immigration because we at 10 minutes.
All right, I'll just wrap it up. And other than these waivers, I've covered these waivers, and in some exceptional circumstances, if the physician is really qualified and really talented, they can also go for this green card process through extraordinary ability. And sometimes the physicians also work in a medically, also get an O visa. And O visa, once you can get an O visa, in case a physician gets an O visa, then you do not have to worry about the waiver. But only time you have to start worrying about when you want to get a green card, then the physician has to get either go back to get a waiver and work in a medically underserved area. Quickly, I'll just also go through this Schedule A. Schedule A seems to be, as I mentioned earlier, Schedule A again is picking up really fast. And in the last 4 or 5 months, we have seen that the EB3 priority dates are moving up really fast. So, Schedule A, unless Schedule A nurses, especially, they are not eligible for getting an H-1B visa. So, the only option that you have for immigrating a Schedule A nurse is through direct green card process. But assuming those Schedule A nurses fall into the category of either the nurse specialists or if they are or a nurse supervisor, in those two circumstances, an H-1B can be filed for the nurses. But other than that, it's only the green card process. And again, as practically speaking, these days, we see that though there are employers to sponsor the nurses, in my practical experience, many of the hospitals that are located within the city, we are in Los Angeles, and many of the hospitals that used to do a lot of these RNs, of late they are not doing it because after 2008 they do have enough people to work in that occupation. But however, like any facility which is around 50 miles away from the city or 75 miles, if they are in a medically underserved area, all those places there is a tremendous demand and shortage for the nurses. So, and we have seen this thing picking up. And people always ask us the question when it comes to nurses, if what can they be filed under the EB2 category? And yes, we do have filed cases for nurses under EB2 category. It really does not matter whether it's EB2 or EB3, as long as we get the necessary prevailing wage determination from the Department of Labor. And if they categorize the occupation as registered nurses, we can definitely do Schedule A nurses under the EB2 category. And physical therapists, it can also fall under the Schedule A, and almost all physical therapists fall under EB2 category, and we haven't had any issues.
Raj, we're approaching 1 more minute. You like to say any concluding remarks?
Nope. No, I'm done.
Okay, thank you, Raj. Well, when we're putting together this panel, putting together all the panels for the Philippines, we want to do something that was unique to the Philippines. And one thing that's very unique to the Philippine immigration is healthcare workers. When you think of a software engineer or a doctor, you think of someone maybe of Indian origin. When you think of a nurse or a physical therapist, you think of someone of Filipino origin. And there's a reason. A lot of the schools in this country, they're geared to enable their students to go to the United States. People who become doctors in India, in the Philippines, they become nurses or they become physical therapists because it's their way to get quickly to the United States. Raj was mentioning Schedule A occupations. The Department of Labor has placed the nursing profession and the physical therapist profession on fast tracks to green cards. So you get to avoid the entire perm process. You go instantly to green cards. And this has led to a huge increase in nursing enrollments and physical therapist enrollments in the Philippines. We mentioned Schedule A occupations. They were very popular in 2000. There were like thousands and thousands of Schedule A cases for nurses filed in between 2003 and 2006. Then there was visa retrogression, and the nurses had a 8-year wait. Many times that we've been encountering was this. I had a work site in. Okay, thank you. Sure. Yeah, I had a work site in Pennsylvania, or let's say in Maryland, and then my client, because of visa retrogression, could not keep that contract. So in 2014, the priority dates became current, about 7 to 8 years after the original I-140 was filed. And this is a typical situation that we have to deal with. Mr. Gorski was talking about the State Department. We have a situation where the original work site was changed from Washington, D.C. or Philadelphia or Pennsylvania to New York. And we had a situation where the U.S. Embassy was requiring a new filing of the perm application. In our judgment, this conflicted with the principles of AC 21, because had that nurse come to the USA as a student, a new labor certification under AC 21 will not be required. It's the portability. You remember when you file a adjustment of status application, and you get to, as long as you work in the same occupation, you do not have to you don't have to have a new labor certification. So I guess my question is to the State Department and to Mr. Gorski, what's your policy regarding the need to get a new labor certification if the work site has changed?
Well, these are Schedule A occupations, right?
Yeah.
And so the decision was based on, we worked with USCIS on this, and it was based not on AC 21, but the fact that since it's Schedule A, the labor cert is not it's not based on a finding that there are no workers available in that area, because the Department of Labor has determined as a matter of law that this job is in short demand everywhere in the United States. So Post has agreed now that they won't be returning these petitions based on a change in work site. but it's based on the fact that they're Schedule A occupations, not on AC-21.
That's a very good news. Many thousands of Filipinos who want to come to the United States, who have their dreams of coming to the USA, will be very happy to hear the answer. Because following a new labor certification will be a huge inconvenience. So, Mr. Boyle, what will be required right now under this new guidance for a RN with a change of worksite situation?
So it's supposedly not new guidance. It's sort of back to the old, but the only thing that we're asking all employers and applicants to keep in mind is that the applicants, of course, they have the right to the going rate wage in the place that they're going to work. So if they were hired supposedly to work in Mississippi, but then their new job will be in New York City, of course, there's going to be a large wage differential. We're not requiring a new petition or anything like that, but we are asking their employer to provide them evidence that they will be paid the going wage wherever they will be stationed.
And that will be based on what's the going wage rate right now, or 2-3 years ago?
Right now.
Well, I think prevailing wage would be the prevailing wage, not going wage. So, but you have to get the minimum and/or prevailing wage, whichever is higher.
So the employers will be required at the interview to show the latest OES prevailing wage survey.
If there's a prevailing wage survey rate for that area, that they would have to meet that criteria.
Right now, today. Okay, I just want to know that. There has been cases which were rejected, unfortunately, and some of my clients have cases where they were refused on the basis of this AC-21. Given the fact that there has been a apparent change of policy, how do they approach the embassy to get their cases reactivated?
So let me clarify. This is something that happened before I got to Manila, and something that changed while I was here. So I'm pleased to be part of the solution. Yeah, I didn't do it, but the relief that we have is probably pretty easy if it was a recent application. If it's still in Manila, as we discussed in the last panel, it's easier to stop. We've also taken the proactive measure of going back to the National Visa Center, where some of them were returned, and we've asked them to send them all back to Manila if they still have them. If they do not still have them, thankfully we're talking about a relatively short period of time, but there are some probably that are no longer with NVC and probably are with the service centers. If that's the case, I think the relief that the service centers can provide is to, if they went all the way to the maximum step of saying you need a new petition, they're saying they are preserving the original priority date. So it's not a total loss. It's not starting over from the start. But those are the things that you can do right now. But right now, there's really not much to do with a case that's been at NVC recently or been with us recently, because we're taking them all back and calling those applicants in for final interviews.
All right. We have to move on a little bit, but a couple of closing questions. A lot of these nurses need work experience. There's a lack of jobs here in the Philippines, so they go to, let's say, Kuwait or Saudi Arabia, and they're working there currently right now. And my clients require them to have work experience so they can hit the ground running. The nurse I flew from Dubai here, and it's 8 hours. Can a nurse go for a ID interview in Dubai, for example, or in Kuwait if they accept it, or they come back here?
The regulation says that you can apply for an immigrant visa in any place where you're a resident or physically present. If they're resident in Dubai, then Dubai rather than Manila would be the place they would normally be expected to apply.
And Mr. Rivera, maybe the POA can, not POA, but the BDI can clarify that. But most of these people who work in these countries are temporary workers. Would that qualify, or resident means your green card?
Well, physical presence, as long as they can establish they can remain at post at the place throughout the period of the IV processing, would also be sufficient to allow them to apply for the IV there.
Okay. All right. I talked about the allied healthcare professions. When it comes to nursing and physical therapy, the Philippines dominate this category. When I was in India, I was surprised and shocked how little knowledge there was for a doctor. For example, if I ask a doctor at a typical school in India how to get to the United States, that knowledge is ubiquitous. Everyone knows how to get to America. But if I ask them how to become a physical therapist or a nurse, no one knows about it. In the Philippines, everyone knows about how to become a physical therapist and how to get to the U.S., and everyone knows about nursing and occupational therapy. So this is a area which the Philippines dominate worldwide immigration trends as far as coming to our country is concerned. The Filipino immigration, latest statistics, 1,200 Filipinos came to the USA in 2000. We estimate at least 1,200 Filipinos come to the USA each year. Out of that number, 25% are healthcare workers, are PTs and OTs. Now, in terms of the physical therapist profession, the U.S. is 57,000 PTs short and 27,000 occupational therapists short. This is due to the baby boomers increasing. This is also due to a lack of admission spots at major U.S. schools, and the Filipinos are filling this gap. Now, when you talk about coming and recruiting in the Philippines, it's a highly regulated profession, and these regulations were put in place to protect the Filipino workers. I have brought in as an attorney, you have to understand that it's not like India where you just concentrate on the H-1B. You got to take into account Filipino law. And we have brought in a gentleman from a Filipino licensed agency that can explain the process of immigration to the United States. Mr. Cesar Rivera of a company called EDI Staff Builders. So, Mr. Rivera, can you explain to the audience the public policy reasons to why the Filipino government has immigration controls over its workers?
Actually, the reason why the POA was set up, it was set up way back 1982. But prior to that, there was also another organization that was set up by the Ministry of Labor just to handle the immigration of Filipino workers abroad, and POA was the one that started that and has professionalized it until now. So what happens is that you have to remember that the Philippines has a population of about 100 million. And we have 10 million Filipinos working abroad. And to think, there are 1,200 recruitment companies in the Philippines. Somebody has to regulate these 1,200 recruitment companies, because you have to imagine that most of the workers that we have, 75% of them are skilled workers. These are the guys that cannot really fight for their own rights. And it is up to the government to protect them. That's why the Philippine government, through the POA, regulates the movement of the Filipino workers, the activities of the foreign employers, and also the activities of these recruitment companies. Because under our system, the recruitment companies, legally, they can charge 1 month placement fee. But you have to remember that there are 1,200 recruitment companies that they have to monitor. And more often than not, that 1 month placement fee is not followed. That is often abused.
Has there been incidents abroad where the Filipino workers were left destitute and ended up at the doorstep of the Filipino embassy?
Well, I think CNN has been very vocal about it, and BBC. A lot of the embassies in the Philippines, in most of the Middle Eastern countries, would have a lot of these skilled workers that were abandoned by their employers, and also the domestic helpers is a major issue by the ILO, that a lot of them ran away from their employers because they were so much exploited and abused. So this is the thing that the POA is really preventing to happen.
But a typical American company that comes here will say the following. My clients, for example, we have the Department of Labor that is very, very vigorous in protecting the rights of H-1B workers. I feel they're more protected than American workers. Why should this law apply to us? We're the United States. We're not Saudi Arabia.
Yeah, exactly. But you have to remember, Ron, the POA does not discriminate each country. They have the same policies for all. So, for example, if you have an employer, we have to accredit them with the same accreditation documents that's needed by all our Middle Eastern clients or our Asian clients. So the same documentation will have to be needed, especially the employment contract should be in place. Everything should be stipulated in the contract, and all of the basic benefits which already given by the U.S. will still have to be. We will still have to add something there, because, for example, the termination clause. You cannot just terminate a Filipino worker because this is a he's an immigrant to your country. So we have to document each termination, and that is where most of the cases happens. So when it comes to termination, when it comes to repatriation, that should be answered by the employer of the Filipino workers.
Does the Philippine regulation of POA have mandatory clauses that must be put into our employment contract?
Yes, and I just want to tell the group that we have started this PT business way back 2002. We were in the U.S. way back that time. We were doing a lot of H-1B visas for our IT professionals from 1996 until 2001. And most of our clients in the IT converted their companies to healthcare, from IT to healthcare. One of these biggest one is based in New York. From a technology company, they became a healthcare company. So we started this PT business, and exactly all the most protected. I agree with you. The most protected worker is the guy that comes on under the H-1B visas. But again, you have to put additional clauses there that is mandated by the POA. And that is one thing is the repatriation, the mandatory insurance, whether you insure them, they're already insured in the US, but they still have to be insured here. And also, there are other clauses that has to be inputted.
If we terminate that PT, we have to pay for their return trip back to the Philippines.
Yeah, it's a must.
But however, I read somewhere that there's a mandatory termination of 30 days. My client has 7 days or 10 days at will. You're trying to tell us that you're trying to tell me that the POA, in order for my client to do business in the Philippines, we got to have 30 days termination notice. They give that worker better deal than our American workers.
Well, actually, that is the intricacies of our labor law. I agree that being in the U.S., being an employee in the U.S. is one of the best things that can happen to a person. But when you recruit Filipinos in the Philippines, you just have to follow our labor law. And under our labor law, it's a 30 days notice, and you have to document the termination or the resignation of the person, because when that guy goes back to the Philippines, he can sue your company, and since you are not based here, your client is not based here, we will be the one that will be answering for them. And that is the reason why we have, I think this is something unique in the Philippines, we have this special power of attorney that jointly and solidarily makes us liable for anything that will happen to the worker. So our major objective here is to recruit the person and to bring him back safely home after the contract is finished.
Can you explain what's involved in this overseas Filipino certificate? For example, suppose an American company comes here, they hire a Filipino. Can that Filipino just get on the airplane at the airport and come here? Come on. How do you regulate that? You're the police. Tell them, I want to see your documents.
So this really is something unique in the Philippines, because every immigration officer in the Philippines are all trained to track down all the Filipinos that goes out of the Philippines. So, for example, and it's just like the U.S. Embassy. The moment that they doubt the credibility of the person, and he's pretending that he's a tourist, and then he will work abroad, then he will be denied. He will not be allowed to take that flight. So all the legal recruitment that happens, all of them have this overseas employment certificate, as we call it. It's called OEC. So the employment certificate will be the one that will allow them to leave the Philippines to work. Without the OEC, then they cannot leave the Philippines.
And what's involved in the OEC? Some sort of
it's just like your health visa requirements, the certificate. So that certificate tells the employer and also the immigration officers in the Philippine government that this guy is fit to work. He is a medical fit. He has undergone all the necessary pre-orientation departure program that is implemented all over the world by the POA regarding the do's and the don'ts of each country that they are working, and all the other things that are stipulated there. So it's a very small certificate, but that's the responsibility of the recruitment company.
Just as a practice guidance, you should, anyone who wants to do business in the Philippines, or if you have clients who want to do business in this country, you should have a reliable company like Mr. Veer's, or a reliable other POA company. POA means Philippines Overseas Employment Administration, to guide you through this process. You should look at them as not as an impediment, but as a partner to help educate your employees, particularly in the pre-departure orientation, because this is one of the areas that you could familiarize your H-1B employers with the intricacies of the H-1B laws, in particular in the extensions. This is one way you could tell an H-1B visa holder that if you have to extend your visa in 2-3 years, you have to file a separate H-4 visa for your spouse. I know this is basics to us, but this is something that's been taken for granted. So the POA company can be your partner in helping manage the expectations of your employees. Generally speaking, Mr. Vera, what is required? Do you have to take a fee from the U.S. company, or do they retain you as a recruitment partner?
Well, each client, each foreign client, they're required to have a licensed recruitment company in the Philippines. In the case of, we have several clients in the U.S. for the last 15 years now. And what they do is that if you are coming here new, then you have to ask the POA who are the best recruitment companies in the Philippines. Normally, they would recommend about 5 or 6 recruitment companies that you can really depend on. Because I have said, in the Philippines, it is legal to charge the worker 1 month placement fee. But the question is, do you accept that? Is that ethical to you? In the case of EDI Staff Builders, we have an organization that we have about 4 members, and since the beginning, we have not charged any single centavo to the candidate.
Can't a U.S. company just bypass you guys? Can we put a advertisement in the newspaper saying Filipino PTs wanted? And can we just have an event here at this hotel without going through you?
Well, you can do that, but you have to go to the jail after that,
Jail?
There are many cases like that, Ron. There are many cases that, especially during the early 2000, when a lot of American companies would just come here, with their counterparts, and then just advertise, and then they just interview. They will be raided by the POA, because the hotels are also advised by the POA that there should be no illegal recruitment happening. Everybody has to have a special recruitment permit before they can have an interview in the office. So you can even do a job fair without the permit of the POA.
Mary, you have a quick comment?
Sorry. Well, I just wanted to let you know that illegal recruitment is a non-bailable offense in the Philippines. So be very, very careful about that. But I just wanted to ask Cesar also about direct hires. So please elaborate on that.
So this is the beauty of the POA. Is they're not only rules and regulation. They're also very positive when it comes to entertaining a lot of major clients. So, for example, if your client in the U.S. has a maximum job order of about 10, then the POA would allow you to recruit these people directly. And that's what we call direct hire. And with that, you don't need any agency. But still, your lawyer should get all the documentation at the POA. And your lawyer should follow all the procedures that's mandated by the POA.
As a clarification, so your clients can recruit up to 10 Filipino workers by using maximum, by through their own private means, like LinkedIn or the internet. 10 at the maximum. But that Filipino worker needs to go to a POA mandatory seminar, and your clients need to sign a compliance certificate stating that you're willing to incorporate Filipino labor law into your contracts. And if the POA likes it, then they will approve that person to immigrate abroad. After 10, you have to retain a licensed POA company as your partner, so you can use to advertise in the newspaper and to hold events at the hotel. All this is in great detail in our article that we wrote. So if you're interested, you can read it. One last question, Mr. Vera. This law seems to protect the employee. My clients spend at least $10,000 to $15,000 overall to recruit a worker to come to the United States. And one frustrating thing is that the worker comes to the USA and after 4 months they leave. After we spend all this money. My clients have legitimate expectations that the person will stay at least 2 years, 3 years. And the U.S. Department of Labor courts have endorsed that concept in principle that an employer has they have liquidated damage clauses, for example, but that's a different topic. What does the POA do to help protect the employer from unsavory employees who took advantage of us?
Yes, exactly. And this is what EDI is always advising the client, that anything that happens to the worker from day one that they arrive, they have to inform us if there's any eventualities. In that case, if the PT leaves the client after 4 months, then the most important thing is to tell us so that we can advise the POA and also blacklist this candidate, that when he returns home, he cannot go back to the U.S.
Really? So that person will be stuck here in the Philippines if we tell you.
Yes, exactly. But the problem with a lot of companies is that they don't tell us. That's why, with respect to the clients of EDI, we do a lot of orientation to our client. We do a lot of bridging program for our clients and also the employees. So we tell them about the rights, and we tell them also the rights of their employer.
Does this also apply to green card holders, or can we avail that if they leave after a couple of days?
It will be hard for green card holders because they're free movement, and also the immigration officer here will never check his or her documentation if he leaves the airport. So
Okay.
the H-1B visa for sure they will check. So he cannot leave. So he will be blacklisted here, and we have done that for some cases.
All right, you have any closing points of what you want to articulate to this American attorney audience regarding the application of consideration of this foreign law into our practices? Because I tell you, my clients had a lot of problems dealing with that. They said, "What is this foreign law to dictate our stuff?" So,
And just a very few words, because we've been, our company has been here in the Philippines for the last 40 years. It's called John Klein's Consultant. And after 4 years, we organized EDI Staff Builders. So we've been exposed to international recruitment for a long, long time. And what we can always advise you is that in any country that you go to, always try to do a lot of due diligence before you come in. Because also, some of our major clients in Europe were victimized by a lot of unscrupulous agencies here because they thought that they were decent, and eventually they have cases against them and them having cases with them. So I think the best thing is to approach the POA, get their advice, because most lawyers will do that, and then the POA would always recommend to you some companies that you can really trust. And most of the companies they would recommend to you are the presidential awardees. And EDI is one of them. There's only about 5 of them.
okay.
And also study the laws of the Philippines, because especially with these nurses now coming up, the PDs and the OTs, and as the other gentleman said about the physician, I think there will be a lot of opportunities for your clients to come here to the Philippines to recruit. And it is always good to protect your client. It's always good to protect your client, and you can only do that by studying the labor law of the Philippines. And it's not complicated, because your labor law is great, and you just have to incorporate some of the protections that we have, because we have inputted this because, as I've said, 75% of the deployment of the Philippines is in the Middle East. 75%, so you can imagine that 7.5 million are all over the Middle East.
Okay, great. Okay, we'll move on to other aspects of the PT presentation. One thing about healthcare professionals, which is different from other parts of immigration, is that a healthcare professional, when you touch a patient, you're required to have minimum levels of English-speaking capabilities. All healthcare workers, PTs, nurses, doctors, are required to have a visa screen certificate presented at the U.S. Embassy to certify that they have passed the English-speaking language examinations. And this has been a frustration point for us attorneys, because we have to rely on the PT or the OT or the RN to pass the exam. So just remember that when you want to hire someone who is an OT or PT, you have to assess their English speaking language skills. So if the number one thing is, I tell all allied healthcare professionals, if you don't know English or you are English speaking is kind of tough, or you're having problems, practice speaking English. I tell Filipino speakers, for example, to take this seriously because they have a 50% failure rate on the critical English speaking exams. Ironically, Koreans have a highest rate of passing the examinations, the practice examinations. So. Mary, should we talk about? We'll get into PTs, or I go into OTs quickly. Okay, an occupational therapist. I will talk about an occupational therapist. What is that? Maybe wondering what's the difference between that and a physical therapist. If a dancer breaks her leg, a physical therapist will enable that dancer to walk. A occupational therapist will enable that dancer to dance again. That's the simple difference. And an occupational therapist, if I have a stroke, for example, I will not be able to hold this microphone. The occupational therapist will enable me to compensate to hold this microphone. Again, these are massive shortage occupations in the United States. We're 26,000 OTs short right now. Simply not enough Americans are getting into this area, and they're desperately needed. One needs a master's degree. One needs to be certified by the national board. You need to get licensed in order to get an H-1B visa. That's the critical things that you should know about. You have to take an examination. As immigration attorneys, we're called upon to discuss the differences between the various education systems and help advise our clients in terms of what courses they need to take. Physical therapists, things that people need to know is the following. You need to travel. With the OTs, you can take the licensing certification here in the Philippines. And that led to unprecedented level of immigration of occupational therapists to the USA. And also for the nurses, you can take the exam here. That's critical because unless you pass the certification examination, you won't get the license or be license eligible in order to immigrate to the United States. For physical therapists, it's a different situation. The critical certification examinations are only given in the United States. So you need to apply for a B1, B2 visa at the U.S. Embassy in order to come to the USA to take the examination. And this has led to, relatively speaking, low levels of PT immigration. That could be a lot higher if the exams are given here in the Philippines. But the physical therapist profession has, in my view, engaged in, I believe, in protectionist measures to keep the exams only in the USA. So I asked Mr. Gorski or Mr. Boyle, what's the issuance of B1, B2s, H1B visas for physical therapists who want to come to America to take the examination? Do you have any statistics as to?
I don't have any statistics on that particular. I do know it happens, and that's a happy thing when it does. But no, I don't have any statistics.
Okay.
So I have a question. So if the physical, if there's an employer who's willing to eventually employ that physical therapist, and they can guarantee that the person can return to the Philippines, would it be easier to overcome the 214B possible issue?
I mean, it's always a question of fact. It goes on a case by case determination. If what's going to happen if they don't pass? I mean, will they come back to the Philippines or not? I mean, certainly if the person has legitimate ties to the Philippines, they're B eligible. But on the other hand, these are all, by their very nature, intending immigrants, since they're applying for an immigrant. Many of them are applying for an immigrant status or an H-1B, and they do intend a long-term stay in the United States. So it may be hard to overcome, but we'll certainly be receptive to the eligible candidates.
As a practice advisory, the Philippines, the consulate in Manila is very aware that Filipinos need to go to the USA to take the examination. I started to do this in India about 5 to 6 years ago, and the rejection rate for physical therapists to get to the USA was approaching at least 80% in Chennai and in Delhi. So it required me and other attorneys to do an outreach to meet with the State Department people to describe the situation. And the to the credit of the U.S. Embassy staff in New Delhi and in Chennai, they were very receptive to listen to us. So as I think is, if you have problems with the embassy, I would strongly recommend that you go there and try to articulate your point of view, give them your story, and I know they are willing to listen. And we have seen the issuance rates for B1, B2 visas for Indians go up drastically who take the exam. Second, you have to educate your clients that this is a great job. These PTs start out at $70,000 to $80,000, and after 3 years, they go up to at least $90,000. And a job that is not being you don't get laid off from a PT or an OT situation unless you are at fault. So many of these guys know that if they fail the examination, they should come back and take and go for another shot rather than overstay their visa because they have too much to lose. So you have to educate your PTs not to stay in the USA because this is a great job for them. So, Mary, you have something?
Just a little practice pointer.
Yeah, go on.
We have 2 minutes. So it's, I believe there's a question. Okay. So just a little practice pointer. The credentialing process and taking the licensing exam takes a long time. So you have to plan ahead. It may take a year for planning for the physical therapist to be able to come to the United States eventually under the H-1B visa. But at the same time, I just wanted to go over the other, the various visa options. Well, of course, H-1B is the easiest type of visa. Well, Singaporeans could avail of the H-1B1 visa, and Australians can avail of the E3 visa. And Filipinos tend to immigrate all over the place, and most of them go to Canada or Australia. They eventually obtain their own Australian citizenship or Canadian citizenship, and so then they can avail of the TN visa. So now the other thing that needs to be that one needs to determine is whether or not one would avail of the EB2 versus the EB3 visa. Now that the priority dates are not that bad and it's easier to reach for the PTs to be able to come in, it doesn't really matter anymore whether they avail of the EB2 visa or EB3. But as a general rule, since the PT business or industry requires a master's degree at a minimum or even a doctorate, then they certainly qualify for the EB2.
This has been a controversial topic at the USCIS. I think they have adopted concerning EB2 situations, but you have to understand that even though the United States, several states are moving towards a master's degree requirement, New York just went into that area. New York has two tracks, one for the American track. If you have an American degree, you need to have a master's degree. One, the foreign track. And the foreign track has a standard substantially equivalent to a master's degree. Many schools in the Philippines simply do not have master's degree programs. But they have baccalaureate degrees, which are 5.5 to 6 years. And they are substantially equivalent to a U.S. master's degree. So, the state licensing board has two tracks to accommodate the foreign physical therapists in their situation. Mary's right. It does take a lot of extra coursework. In India, for example, the occupational therapists have to take about 6 months of special online coursework in order to have their degrees to be equivalent to a U.S. master's degree. One other thing, too, about the licensing examinations is designed to test out the entry-level knowledge of a new healthcare graduate. This could be a doctor, physical therapist, nurse. Many people who take many foreigners who take foreign healthcare professionals who take these exams are very experienced. They have 10 years of experience, but they approach the answer through their experience and not through the perspective of a new graduate in their field from the United States. And we see high failure rates of experienced healthcare professionals on these healthcare examinations compared to American graduates who have high passing rates. So you have to tell your foreign healthcare professionals who you happen to recruit, saying you have to know and answer it through the perspective of a new American graduate and not through your great healthcare experience. We are now, I guess, ending about 10 minutes early. I guess we have questions. Anyone who has questions, I'd be more happy to give it to the floor.
For the overseas employment certificate, do you just have to get that once at the start of your first H-1B or your first L, or do you have to get a new one for every visa renewal or for every departure from the Philippines?
So you have to get it every time that the worker goes back for vacation. Yeah. So but it's very easy because that can all be processed at the POA, and they can do that in about 4 hours time. But in EDI we are licensed to give it in house. So when our healthcare professional goes for vacation, they just report to our office one time, and when they're dispatched, we just give it to them. But every year it has to, when the guy goes home every year, it has to be secured at the POA so that they can still leave the country. Because as long as they are not green card holder yet or American citizen, that will be required at the immigration office in the airport.
Suppose a a Filipino software engineer or physical therapist, after 2-3 years, resigns from my client, who's the original employer, and we have under an obligation to cancel their H-1B visa. Should we notify you that we canceled their H-1B visa? Or?
Yeah, I think the most important thing, as I've said, is you have to notify your agency in the Philippines so that they can make the necessary action from their side, and also to advise the POA that this guy did not renew his contract or terminated his contract or did not finish the contract, so that at least the POA would know that that guy is not registered under your company. Because for as long as you don't tell us, under the eyes of the POA in the computer system, that guy is still your employee. And that's dangerous, because something happens to that guy, then your client is still responsible for them.
Even if he works for another employer?
Yeah, you have to tell us, because under the eyes of the POA, he's still working for you.
Now suppose...
But that's part of our orientation for our clients. We tell our clients about this procedure, so it's not something new,
Suppose that physical therapist or occupational therapist finishes his or her contract or terminates the contract prematurely and works for a second company. Is that second company, suppose that H-1B transfer situation is one of my clients.
Yeah.
Am I required to tell my client that they had to be POA compliant, even though they had the original, they came over originally? Must the second employer go through the whole process all over again?
Well, in the case of that, so if the original employer should advise us that this guy is leaving them. Now, after that, your obligation as the original employer ceases, and that responsibility goes to the second employer.
And so if the person comes home to the Philippines and attempts to leave the country, under the original certificate, that'll be invalidated, and the new employer has to go through the process.
Yes, exactly. They have to be registered. They have to register themselves.
No, go ahead. There's another microphone. I just want to make sure to find out how enforceable are those conditions.
It's only enforceable if you tell us, because that's why it's very it's part of our process that we have to advise the client about all the procedure of the POA. That's why I was saying that even before your client decides to go to the Philippines, please study the rules and regulation of the POA, because it's very simple. But the problem is a lot of companies takes it for granted, because sometimes they know better, and even if their conditions for employment is better, there are some conditions that are required by the Philippine labor law that has to be inputted there,
Okay.
And that is where the dissatisfaction or the cases happens, misagreement,
Mary?
Okay. Okay, good. So, but I just wanted to let the audience know also that the Philippines is coming up with its new immigration reform, its own immigration reform. There's an immigration act that existed since 1949, and it's the first time that they're overhauling it. And I think they're becoming more and more attuned to the times that they have to attune to the times that there are anyway, in order to be able to accommodate the economic situation of the Philippines. But also at the same time, I think that the POA rules have to be overhauled, and I think that's something that needs to be.
Actually, we have been crying for that. I think all the recruitment companies has been crying for that because it's not only the American companies. We have a lot of Japanese clients that are in the gas and oil industries, and they can imagine if they submit their documentation. If one document is missing, they will say, don't they know us? We are Chiyoda Corporation. They don't know us. And I said, they know you, but you still have to submit all these documents. So these are very basic because you have to imagine that the guys processing it are just really following the rules and regulation because any mistake that they commit, they're also liable. They're also liable.
I got a question for Mr. Boyle. Do you have any interaction with the POEA about any type of? Do they complain to you about certain U.S. employers who are unsavory?
I can't really talk about the POEA very much, and I don't know what the extent of our contact is with them. But I will add, I deal with immigrant visas at the embassy, and for those of you who have clients who are obtaining immigrant visas, it's notable to also to write down that there is a commission on Filipino overseas, and that is another. It's sort of for immigrants that are leaving the country. They also have to stop in with the Commission of Filipino Overseas. It's a requirement. They can't leave the country without it. Some immigrant visa applicants who get their immigrant visa have gone to the airport without taking this important step. And once more, the immigration officials in the Philippines are telling them, sorry, you can't board the plane until you have the stamp in your passport from the Commission of Filipinos Overseas. So it's a parallel track for the immigrants leaving as it is for those who are working abroad.
Okay. We got about 2 more minutes. Any other questions? Nikki?
Before that, yes, we recommend that the person goes in after they have their visa renewed. Is the visa itself good evidence that they would need to get that certificate, or can they just do it, at any point during the time that they're back?
They're only required to get it when they go for vacation, and then when they leave, they have to present that, and that is the requirement. They cannot live without that OEC certificate for as long as he is on contract. Under the H-1B visa, he has to produce the OAC.
Does that apply to also L-1B visas or any type of visa or just H-1Bs?
I think it's only H-1Bs, It's, yeah.
Any work, does it apply to all working
The
visas?
L1 will be for the intercompany transfer.
Yeah.
Yeah, they need it.
So all working visas.
Yes, all
There's no
working visas.
exceptions.
Yeah, exactly.
Well, even entertainers, they have to go through POEA.
I guess we have time for one more. Whoa.
We're gonna be late to the U.S. Embassy.
Okay.
We're supposed to stop at 10:30.
Okay. Thank you very much.
One more.
Could you let us know where to find the documents for the conference? Oh, you will? Okay.
Thank you, folks, for coming to Manila, and give it to